Some of you all there are still people joining in. Let them join, and we will begin commence our class for today. I don't know whether there are people who are joining in for the first time today, and for those who are joining first time, talk to your colleagues and see what we've discussed last week. We've been discussing, or we commenced, bills of exchange ordinance, the history behind it, certain aspects, and we had a provision into that. So I'm taking a bit of time in comparison to the other topics on bills of exchange and checks, due to its importance, as well as how frequent it is that you come across questions in the exams. Therefore, my intention today is to finish bills of exchange in terms of bills of exchange, but more specifically, I will be touching upon loan checks, which is also part of bills of exchange, but it's somewhat more specific, and there are many things in addition to bills of exchange that grew as part of customs and law of banking with regard to checks. So we will be discussing and hopefully concluding the bills of exchange, and maybe next week we can complete loan checks. All right. So if you have any questions on this, like I said, I've shared my details last time. You can submit your questions to me, and I will get back to you. I didn't get any questions unless I've missed any of them, which brings me to the conclusion that you are now very well versed with what we discussed last week. Nothing else, right? Okay. So we've discussed up until on the order checks and the bearer checks and the effects thereof, right? We will continue from there. I hope you all have your bills of exchange ordinance with you, right? Now I'm coming to section on the capacity of the parties. But before I go on to the capacity of the parties, you would recall that you learned in law of contracts, or law related to contracts, so basics, elements of contracts, basics of contracts, an element called capacity of the parties. What is capacity of the parties? Capacity of the party to a contract, which is an element of the condition of a contract. You can type your answers, you can unmute and partake in the discussion. What is capacity of contract? Capacity of the parties to contract, rather. Yep. Capacity. Quilini? Any guesses?
Yes, sir. So can you repeat the question again, please?
What do you mean by capacity of the parties to a contract? The legal capability to enter into the agreement. Kirtana says above 18, age above 18 and mentally sound is capable, mentally stable. Do you think you all are mentally stable? You all have the capacity to contract. I presume is the general presumption. Not be drunken. Good. What else? Where do you find these things? How do you know? Where? Yeah, some of you have said above 18. Why? Kirtana, you said Kirtana and Malmi has said above 18. Why? Where did you find this above 18? Why do you say above 18? Is the question. Why above 18? Power to legally bind themselves to a contract. Yes. Malmi? Why? No
It is
idea.
considered as age of majority.
It's considered as age of majority. Also, you are correct. But why do you? Why? Who consider that as per what?
It is not valid if they if they are not above 18. It is not valid.
Good, good. Why do you say that? What do you mean they are? It's not valid.
If we take an example, I will say this. If he is used, if he breached any contract under 18%, we can't use him because he is not legally attached to any. If he given a loan for him, is not able to repay because he's not in a work. He's not attached to any working position under Sri Lanka.
Okay, goodness. Under Sri Lankan law.
So it's mean a major only. Sorry, sir. It's mean a minor is anyone who has not turned to 18. They can't be a contract to the contractor. So definitely the person would be the person would be turned into the major.
Major, not major general. My
So I think
question.
there's an act called for that thing. I think there's an act, Age of Maturity Act.
Okay. What does that say? Yes, Alpha.
Unless it's a contract for an essential thing, a major cannot enter into other contracts, I think.
Good reading. Age of Majority Act spells out what when you become an adult. So, see, this is the thing. It's you have to be very careful when you are using the words with regard to, especially on law. And when you say you don't have the capacity to enter into a contract unless you are a major, as it is literally, that's not a correct statement to say. So, how it is corrected? It should be unless it's an essential thing. Unless it's an essential thing, you cannot, unless you are a major, you cannot enter into or you don't have the capacity to enter into a contract, right? If you are a minor. We are still speaking on one aspect of it with regard to the age pertaining to a contract. So what's an essential thing? What do you mean by essential?
Necessities.
Can't hear. What is an essential thing?
Necessities.
Necessities. You just gave me a synonym, but I want you to describe what you mean by a necessity.
Like clothes, foods.
Clothes, food. What about a vehicle? Is it an essential thing or no?
No.
These are general questions, so you don't need to worry about. Is it an essential thing or no?
No.
No. Who said no? Somebody said no. Others? Yes, Tyagaraja. Yes, Quilini.
I also said no.
You said no. That's why you raised the hand. Forgive me for my ignorance. Okay. Others? Alpha? Yes, there's quite a few here today. Others, no idea. What about a phone? Mobile phone? Essential or no?
No. No. No.
No. See, some of the answers that I'm getting are like, no, as in like ending with a question mark. Some of the answers are like no, as in couple of dots after that, and some of them are only full stop. Which one is it? Are you sure or no? See, how do you define essential? Right? How do you define essential? Essential to me might not be essential to you. Right? Fiber optic internet access. Ineshi or Lakshila, Shehan, tell me, fiber optic internet access, is it an essential thing or no?
No.
No.
No, sir.
Well, what do you know? Fiber optic internet access is essential for me, right? A phone is essential for me, right? A library is essential for me, right? Two PCs, at least two PCs are essential for me. But somebody might say may not be essential for anyone. A vehicle is essential for me. May not be the case for anyone else. A helicopter is not essential for me, but it may be essential for someone else. Understand? So the term essential is a subjective term depending on the person. So something essential for one person may not be essential for someone else. Therefore, you cannot look at it objectively. You have to look at the lifestyle, life standing of that particular person, right? Therefore, what I'm trying to say is, when you say yes, it's we are still talking about one aspect of contracts, right? Capacity. In terms of capacity, only one item, age, right? Age is only one item. So minus certain things are essential. Why I'm trying to say that is, for an example, clothing and food, basic necessities for human beings, right? So there's no question about it. For, let's say, a miner goes to a store, right? Buy a packet of biscuits, let's say, 20, 50, 100 rupees, whatever. Some of you all may, he says he's hungry. Some of you all may define that it's an essential thing for him. Some of you all may define that it is not an essential thing for him. Based on that, we can enforce the contract. If it is essential for him, that's a valid contract. That's what basically this means. If it is not essential, it is not a valid contract, so it's void or voidable, right? You can invalidate it on the option of the parties, or you can keep it valid, whatever. For easiness of understanding, we'll say either it's legal, valid or invalid, right? If he's hungry, someone might say, why should he? Why did he take a packet of biscuits? And somebody may even go to the extent of identifying what brand is it. He might have got a Danish some biscuits or cookies. Then you might say, if you are hungry, you can go for something else. It's an argument, it's a discussion altogether. But then again, what I'm trying to prove here is invalidating or validating the contract in terms of age is subjective. It depends on the person's capacity to contract. Nevertheless, adding to what some of you all commented, suing or being sued if you are a minor is not taken away, that right is not taken away by law. You can do that. Only thing, you will be appointed with a guardian. That's a procedural thing. But insofar as you are concerned, you are suing him. Right? So don't get confused with those. So capacity, we are coming to that. That's age is one part of it. Then soundness of mind. If you are sound, or if your mind is unsound, then you don't have the capacity to enter into a valid contract. It could be valid or invalid, or in other legal terms, you call it void or voidable. Right? Then lunacy, again, in the study of law, you get this, permanent lunacy, temporary unsound of mind, statuses like that. Don't worry about it. Basically, unsound of mind. Then again, you call what you call drunkenness. Again, that comes to unsoundness of mind temporarily, right? You are not mentally sound or capable of doing that, right? Okay. Now, under what law? This capacity of the parties is governed in Sri Lanka? Now, this law of contracts, before you answer that question, law of contracts in Sri Lanka is governed under what law?
Roman Dutch law.
Law of contracts.
Court law?
Yes, it's basically English law, but turn to section 21. I will present this. Capacity and authority of the parties. Capacity to incur liability as a party to a bill is coextensive with capacity to contract. Right, so it's basically more or less the same. What this says. Where such capacity is to be determined by the law of Sri Lanka, it shall be determined by Roman Dutch law as administered in Sri Lanka, subject to the provisions of an enactment affecting law. Insofar as capacity is concerned, in bills of exchange, that part will be governed under the Roman Dutch law. That's what this says. So Roman Dutch law supersedes English law on checks with regard to capacity. Keep that in mind. That's what I wanted to bring to your attention. Right? What do you understand by the term consideration? Consideration.
Should have a value.
Should have a value, but what is explained consideration?
What the person can
Which is acceptance on the transaction.
Acceptance of the transaction, not quite.
what a person can get in enter into the contract.
Yes, no, not in enter into the construction. It's what you get for what you give, basically. Quid pro quo, tit for tat, whatever. In Sinhala, you call it pratishtava. Under the law of contracts in Sri Lanka, you need valuable consideration. Right? Agana pratishtava. Keep that both parties giving something for the contract. Yes, you might be buying goods and in return you are giving money, valuable consideration, right? Then consideration need not be adequate. Need not be the same. It should be only adequate, right? Right. Then say I'm going to section 27 just to explain this part of consideration for you. How it affects bills of exchange ordinance. Consideration for a bill. Valuable consideration for a bill may be constituted by, look at this, by any consideration which by law of England is sufficient to support a simple contract. So basically, we all know that, right? It's a basic understanding. An antecedent debt or liability, such a debt or liability is deemed valuable consideration whether the bill is payable on demand or at a future time, right? Antecedent. Earlier debt also or a liability is considered as a valid consideration in terms of bills of exchange ordinance, right? Now, for English law, you need valuable consideration, but under Roman Dutch law, consideration you don't need it to be valuable consideration. රෝමලන්දේසි නීතියේදී අගනා ප්‍රතිෂ්ඨාවක් තිබිය යුතු නැහැ ප්‍රතිෂ්ඨාව පමණක් සෑහීමකට පත් වෙනවා. So consideration itself was sufficient. But when it comes to a check or a bill of exchange, you need valuable consideration. There should be something in money, monetary terms, or otherwise. So you should give something or forbearance, you call it. So to do something or not to do something. You might say, don't, let's say, don't file action against me, right? Because of you not filing action against me, I will do this. So that's forbearance. Or don't file action against my son. Because you are not filing action against my son, I will make sure that I'll give you this amount. That's a forbearance. That's a valid consideration, right? In this case, the case is right. I will type it up. Right. Now, in a court case, you know, there are two parties. The plaintiff, that is the party who is filing the action against the defendant. Now, in this case, this plaintiff, right, the party who filed action against the defendant is the brother, right? No, I put it like this. Now, plaintiff is defendant's brother's mistress. Take some time to sink that in. Plaintiff is defendant brother's mistress. So, his brother's mistress. So plaintiff had two children from the brother of the defendant. Now defendant, this was when it was in Ceylon, was going abroad and was leaving Ceylon. At that time, the defendant told plaintiff that he will give, he gave a promissory note. Promissory note, is a bill of exchange, for the sake of the children, to make arrangements for the living and all, right? But it's not, he gave it on his own accord, on his own volition, but not from and on behalf of the brother. Defendant just gave him out of sympathy or whatever. Then it didn't go through. Then the plaintiff filed action against the defendant. First thing, is there a contract or no here? Is there a contract here or no? Plaintiff was given a promissory note by the defendant because the defendant's brother left the plaintiff and went abroad. Is there a contract between plaintiff and the defendant? Yes or no? No, it's a social arrangement. Okay. What else?
Promissory note considers just like as security, most probably.
Security for what?
For a facility or something like that, loan or credit facility.
Yeah, but then again, we are in this context. The defendant gave this promissory note to this lady because his brother left her and left the country. As a favor, he gave the promissory note to maintain the children. He did not get any consideration from her, right? He did not get anything from her. Now, by now, you should be able to answer this because that's why I gave that description initially. That's why I explained about the consideration and the law related to consideration and etc. Yes. Considered. No argument says that no offer was made by the plaintiff.
There's a contract.
There is a contract. Also, what's the contract?
In
Can you
terms
say
of
there is? Okay, sorry. Go ahead.
in terms of consideration, there's a not in monetary terms, but she's looking after his children.
No, she's not looking after his children. She's looking after his brother's children.
Yes.
Okay, because of that you are saying there's a contract. Okay. Not legally binding, no agreement, hence that no offer was made by the plaintiff. Now, can you give me examples? We'll park it right over there. And can you tell me examples of valid contracts which there is no consideration in Sri Lanka, but they are legally valid? What are they? Or are they there in existence? Valid legally binding contract, but there is no consideration.
So Tagiopu.
Yes, deeds of gifts. Why is that? Because insofar as that is concerned, the law of contract there in Sri Lanka, it's governed under Roman Dutch law, and you don't need a valuable consideration under Roman Dutch law. So if it's a deed of gift, one party is gifting the other, but for the sake of writing in the deed, it says in consideration of love and affection, right? In consideration of love and affection. ආදරය කරුණාව සහ දයාව what I'm getting, I'm giving this. That's why there is a provision that for gross ingratitude, you can invalidate the contract. So similarly, there need not be necessarily a valuable consideration in Sri Lanka, but consideration should be there. But here, on the one hand, you can argue that there is no consideration whatsoever between the plaintiff and the defendant. Defendant gave a, Shehan has mentioned it's a social arrangement. That those traces also are there. I'm not saying no, but what I'm trying to say here is someone may argue that there is a contract, someone may say there is no contract. He just gave it out of sympathy, let's say. If it's out of sympathy, there is no consideration. But here, we don't need to go on that. This lady sued on the promissory note. Then all those legal complexities, whether it's a social arrangement, whether there was a consideration passed, whether there was a contract between these two parties, are all irrelevant because she sued on the promissory note. For promissory note is a bill of exchange. For bills of exchange, you need valuable consideration, not just consideration. You understand? Therefore, the court held that no, it's bills of exchange. It's a bill of exchange. It's governed under the bills of exchange ordinance. Under section 27, one of the bills of exchange ordinance, there should be valuable consideration. There is no valuable consideration passed from the plaintiff to the defendant here. Therefore, she doesn't have a case. No, to the it was written to her. It was written to her. Even if it was written to the children, there cannot be held a legally binding agreement because it's again from the children to him. There is no valid consideration, valuable consideration. Right? Understood? No intention? Yeah. So what I'm trying to say is you don't have to go to those legal complexities. You can simply, conclude it based on the fact that it is an action based on a bill of exchange. Right. Okay. So we slightly touched upon as to who are the different parties to a bill of exchange. There is a drawer. Who is a drawer? Who is a drawer? Who is the drawer of a bill of exchange?
The person who draws a bill.
The person who draws the bill. Who drew it, yeah? Section 55. Section 55. The drawer of a bill, by drawing it, engages that on due presentment it shall be accepted and paid according to its tenor. Tenor means the body, yeah? And that if it is be dishonored, he will compensate the holder or any endorser who is compelled to pay it, provided that the requisite proceedings on dishonor be duly taken. Now, basically, this is one of the pivotal factors or one of the important points of bills of exchange ordinance, and the lining, the golden thread woven in between through the bills of exchange ordinance. If not for this, there is no validity, or it won't be this popular. But basically, does this say if not for this clause, right? The use of bills of exchange won't be in existence. Why I'm saying that? This is the clause which makes the drawer liable. If the drawer of a bill is not liable on the bill, to whom the payee or the endorsee would turn into? Nobody. So he is liable. Look at this. According to how it was written, according to his tenor, the body, he will compensate the holder of the bill or any endorser who is compelled to pay, right? Because that's the chain of command. the person who is holding the bill should have a recourse on the bill. This recourse comes from this section 55. Then we have the drawee. Who's the drawee?
The party on whom the order is given.
Very good. Very good. The party on whom the order is. Turn to section 53. See, I am going these sections one by one just to ensure that you have a sufficient understanding of these. When you've been tested or during the examination, you should have an ample understanding of what these parties are. A bill of itself does not operate as an assignment of funds in the hands of the drawee available for the payment thereof. And the drawee of a bill who does not accept as required by his ordinance is not liable on the instrument. So basically, just because you write a promissory note, let's say a bill of exchange, you say, I'm saying, I'm the drawer of the bill and I am giving it to, let's say, party A, who is the payee, and the drawee here is, let's say, party B, who does not owe me anything. He's not liable on the bill, and he doesn't make him a drawee. He needs to accept the bill. That's why the acceptance part needs to be there. If he's accepted, then he becomes liable on that. If there is, he would accept it if he owes me something. Otherwise, it doesn't. Right? Okay. Then now we come on the understood on the drawer and drawee. Now we come on the endorsement point. Right? What is endorsement? Right? This again comes from the word endorsement, but in common parlance and the banking culture, we call endorsing. So, right, endorsing and endorsing. Endorsing is the correct legal term, right? Endorsing is, kind of approving it. So something similar to that, but the correct legal term is endorsement. To write, that means to write someone's signature or to sign on the back of that instrument, giving you approval, basically synonymous as endorsement. We go to the interpretation under section 2. Endorsement. Endorsement means endorsement complete by delivery. Insofar as bills of exchange ordinance is concerned, it's not sufficient that you just sign it and keep it with you. You need to deliver it with your endorsement, with your approval. If it is not delivered, when I mean by delivered, it gives you the requirement of intention to deliver. If it is taken from you, no, it's not in. For an example, I'll give an example. Somebody draws a bill of exchange, the drawee is there, pay is there. Pay can endorse it. The original pay, let's say, endorses it, right? And put it in his drawer. Endorses it in blank and put it in his drawer. I'm just giving you a hypothetical example. Let's say order bill, right? If somebody steals it, that's not a valid endorsement. If you can prove that he stole, there should be delivery of the bill. That means intention to endorse and give it to someone else. That needs to be there, right? So we come to section 55. You have to write these things down, otherwise you will never remember this. The liability of the drawer. the endorser of a bill by endorsing it engages that on due presentment it shall be accepted and paid according to its tenor, and if that is been dishonored, he will compensate the holder by subsequent endorser who is compelled by right. He is precluded from denying to a holder in due course the genuineness and regularity in all respects. Precluded from denying to his immediate or subsequent endorser that the bill is at the time of his endorsement a valid and subsisting bill. Basically, after you endorse and deliver it, you warrant the title of that. You are liable on the bill. You endorse and give it to someone else, right? Let's say your supplier or whoever. You become responsible from that point onwards, not only to the person that you gave, but all the subsequent people who he endorses and gave. Right? Similarly, you will also get the protection of the person who endorsed and gave you when you were at that time a payee or other endorsee for him and from him until the initial drawer. All in the chain is liable. Right? Now, forged endorsements of a let's see how this works, right? Section 24. Forged or unauthorized signature. Provision of the oath. Where a signature on a bill is forged or placed thereon without the authority of the person whose signature it purports to be. The forged or unauthorized signature is wholly inoperative, and no right to retain the bill or give a discharge therefore to enforce payment thereof against any party can be acquired through the or under the signature unless the party against whom it is sought to retain or enforce payment of the bill is precluded from setting up forgery or want of authority, provided that nothing in this section shall affect the ratification of an unauthorized signature not amounting to forgery. Read this section. This is an important section. Read this once. I will explain. See, there is no endorsement of a, or the topic of endorsement of a bearer bill, because bearer bills are transferable based on possession, transfer of possession, transferred by simple delivery of possession. So there is no thing called endorsement of bearer bill, right? So if in this case of Don Cornelius versus Desois and Company Limited, Supreme Court held that forged endorsements are wholly inoperative under this section. So if it's a forged endorsement, nothing. It's inoperative. It's not valid, right? Now, who is the holder of a bill? Right? There are two things I want you all to understand when it comes to a bill. A holder, a mere holder, and a holder in due course. Legally, we call HDC. Right? Who is a holder, we'll say? Holder means the payee. You know who the payee is. Or endorsee of a bill or note who is in possession of it, or the bearer. Let's say cash or bearer, I hold that bill, right? Then I am the holder. I may not be holding it, or I may be just, I may be holding it, for an example, in trust of someone else. Somebody said, okay, For an example, I'll give you an example. Right? He will say, hold this bill for me. He's the holder, right? There is no legal rights per se that he would be entitled to by just being a holder. By just being a holder. He may not, he may or he may not by just being the holder. Because in order to become a holder, only need to be is that he should be in possession of the bill. Then he becomes the holder. That doesn't, or that might, that alone might not give him certain legal rights on the bill. He may be just holding the bill in his possession. Somebody might say, put this into your drawer until I come and collect it tomorrow. He is the holder of the bill, right? But what is important is the legal rights entails not to the holder per se, but to the holder in due course, HDC. And holder in single we call it Dharakya. Check pata ho vinimaya vilpata ate daragani sitinna Dharakya or holder. Holder in due course, Yata Kale Dharakya. That is the person who gets all the legal rights that is deriving upon the bill of exchange. 29. Holder in due course, right? A holder in due course is a holder who has taken a bill complete and regular on the face of it under the following conditions. Just a holder, who is in possession of the bill. But for you to become a holder in due course, it's not enough for you to just say that you are in possession of the bill. You need to be a holder who took the bill, a complete bill, and regular bill, a regular one, which is not altered or tampered with, right, on the face of it, under the following conditions. What are those conditions? That he became the holder of it before it was overdue. It's not expired. And without notice that it had been previously dishonored. So it wasn't dishonored. It's a fresh bill of exchange. It wasn't dishonored earlier. Neither it is expired. That he took the bill in good faith and for value. Just contrast this with the holder and the holder in due course. He took the bill in good faith, bona fides, and for value, for valuable consideration. Remember, right? He didn't steal it. He didn't just took it by force, right? And he gave something for that. Consideration, valuable consideration. Or he forbade certain things in taking them. Or he may have given services, whatever. He became a holder in due course, right? And he had no notice of any defect in the title of the person who negotiated. In addition to that, so it's not enough that he became the holder of it before it was expired, or the fact that it was not dishonored, or he took it in good faith for value, and then at the time the bill was negotiated to him, he had no notice of any defect in title. See, if all those things being there is not enough, if he knew that the person who gave you the bill of exchange stole it from someone else, if he knew that fact, done deal. Even if he has given valuable consideration on the transaction, he doesn't become a holder in due course, right? What do you mean by holder in due course? What do you get out of being a holder in due course, right? Holder for value, he gets to sue on the bill. He gets certain rights on the bill, right? He gets certain legal rights on the bill. Now, how do we know he's a holder in due course? We wouldn't know. See what I just explained in close numbers are close to. Particularly, the title of a person who negotiates the bill. So, what from I'm a holder in due course, and from the person who gave me the bill, if the bill is defective within the meaning of this ordinance, what do we mean by that? If he obtained the bill or the acceptance by fraud, duress, force, fear, or other unlawful means of an illegal consideration, or when he negotiates it in breach of faith or under such circumstances that amount to fraud, right? වංචාව, බය ගැන්වීම, අයුතු බලයෙන් පාවිච්චි කිරීම, බය ගැන්වීම මගින් සහ අද මේ අනීතිකකම මගින් ගත්තොත් is not a holder in due course, right? Presumption of value and good faith. So in law, you can't always know that he is a holder in due course, so he is not a holder in due course. Therefore, there are certain presumptions as to who is a holder in due course. Every party whose signature appears on the bill is on the face of it, prima facie deemed to have become a party thereto for value. So whenever your name is there, there is a presumption that you are holding in due course, right? Every holder of a bill is prima facie, that is on the face of it, deemed to be a holder in due course, right? However, if an action on a bill, it is admitted or proved that the acceptance, issue, or subsequent negotiation of the bill is affected with fraud, duress, force, and fear or illegality, or burden of proof is shifted unless and until the holder proves that subsequent to the alleged fraud or illegality, value has been has in good faith have been given for. So on the face of it, he or she is deemed or considered as a holder in due course until proven otherwise. If other facts against that position is submitted, he needs to prove that how he is telling that he is a holder in due course, right? අනිත් පාර්ශවය විසින් කරුණු ඉදිරිපත් කළොත් මෙයා යථාකාරී දායකයෙක් නොවේ, මෙයා මේක අනීතික ලෙස ගත්තු විනිමය බිල් පතක් කියලා ඔප්පු කිරීමේ භාරය අර ධාරකයා වෙත පැමිණෙනවා නැමෙත, right? Right. Then right. Now you know signature. Any questions? Any questions? Up to now? No? Okay. Now you know by now signature is an essential element for you to become liable. Right? Signature is an essential element. No person is liable as drawer, endorser, or acceptor of a bill who has not signed on it as such, right? Section 23 says that. We just read it. However, a signature may be written by someone else by you under his authority. If you have given someone else to, write the signature or the name, you are liable on that. Section 93(1) states that. Right? If a person signs it as your agent, that person is not liable, but you are liable. Right? That is understood. Forged or unauthorized signatures. Since a bill which is a bearer bill, payable to bearer, is negotiated by delivery, the fact that the signature is forged is irrelevant, right? Because if it's a bill payable to bearer, a forged or unauthorized signature is wholly inoperative, though such signature no rights can be obtained. Section 24, I'll just explain this to you a little further. What we just discussed, right? What you just read. Where a signature on a bill is forged or placed without the authority of the person who signed it, forged or unauthorized signature is wholly inoperative and no right to retain the bill. or to give a discharge therefore. Right? However, if it's a bearable, then the issue of forged signature doesn't come into play. In this instance, when I say forged signature, that is the signature of an endorsement, not the drawer. Right? If it's a bearable. Understood?
So can you repeat again the same thing?
Pardon?
Signature of the bearer, that endorsement signature on.
Yes. See, when it's a bearable, there is no question about endorsement. By delivery alone, it's transferred. So even if the endorsers, if somebody endorses or a forged signature is there on the endorser, for an example, let's say, A. Amila Pereira or bearer. Drawer says, Pay Amila Pereira or drawer, so or bearer. And he gives it to Amila Pereira. Amila Pereira's secretary, without Amila Pereira's knowledge, takes that, endorses or forges Amila Pereira's signature at the back and gives it to someone else. It doesn't matter that endorsement is forged because it's a bearable anyway. You don't need to endorse that. Okay.
Yes, sir. Thank you.
The other pay, similar thing. The other pay is fictitious or non-existing person, like Spider-Man. Last week we discussed. It's a forged signature, effectively passes the title since such bill is regarded as payable to bearer. Section 7.3. Maybe certainty required as pay. Third one, where the pay is fictitious or non-existing person, the bill may be treated as payable to bearer. First one, where the bill is not payable to bearer, the pay must be named or otherwise indicated there in the bill may be made payable to two or more payers, whatever. If it's a fictitious one or non-existing person, it may be treated as payable to bearer. Right? So, coming back to the example we discussed, you could treat it as a bearer bill if it says cash or order, or if it says Spider-Man or order, because if it's a fictitious or a non-existing person. But then again, banks don't do that because of risk aspect of it. Understood? That's why they decline it. Technically speaking, you can, but then again, technically and the practice are in two different ends here. Now, in this case, this is different. This case goes like this. A clerk employed by the plaintiff, this clerk employed by the plaintiff, induced the plaintiff to write text to B, fraudulently representing that B had performed services. B didn't perform actually services to plaintiff, but plaintiff's clerk induced plaintiff to write checks in favor of B. The clerk endorsed the checks with B's name and negotiated them to the defendant. So plaintiff wrote the check, pay name as B. Actually, B didn't do any services to them, but the clerk endorsed the bill, fraudulently representing endorse checks with B's name, right? B's name. Give me a moment, Ladit. B's name. He forged the signature. The defendant presented them to his bank, who honored them. There was no person as B, actually. Although the plaintiff at the time of drawing the checks believed there was such a person, right? B came within the meaning of fictitious or non-existent person, and therefore the checks were held to be payable to bearer. Accordingly, forging of the signatures was irrelevant since no endorsement was necessary to pass the title. Yes, any questions? Questions? No questions? Okay.
Excuse me, sir.
Yes, Vineli.
Well, you mentioned that even if it's a fictitious person, it's you can treat it as a payable to be bearer.
Yes.
So, you said legally the bank would not pay it,
Yes.
right? So,
Yes.
so it's a breach of law, right?
No.
Isn't
It says it may be paid. It's not it shall be paid. There's a discretion to the bank. Bank, if really want it, can pay, but not in this world. They won't pay. It's a discretion on the bank,
okay, sir.
right? Now, this is another famous case. Bank of versus Brothers. Pagliano Brothers, 1890. Bank of England versus Pagliano Brothers. Now, although there, in this case, although there was a firm, in fact, in whose favor the bill had been drawn with forged signatures, right? The bill was held to be payable to bearer because the person who actually drew the check had no intention that the payment to be made to that firm, right? In this case, the names and signatures of the drawer, names and signatures of the drawer and payee had been forged by a clerk of the acceptors, who thereby obtained the money, right? So it was said that although there was a firm in fact in whose favor the bill has been drawn with forged signatures, the bill was held to be payable to bearer because the person who actually drew the check had no intention that the payment be made to that firm, right? Then we go on. There are many cases on negotiation of a bill of exchange, right? How would we negotiate a bill of exchange? We come to section now. For a negotiation, for a valid negotiation, there should be a valid endorsement. Settlement of dates, right? Negotiation bills. A bill is negotiated. A bill is negotiated. Section 31 says a bill is negotiated when it is transferred from one person to another in such a manner as to constitute the transferee the holder of the bill. Right? A bill is negotiated when it is transferred from one person to another in such a manner as to constitute the transferee the holder of the bill. A bill is payable to bearer is negotiated by delivery. We already know this, right? A bill payable to order is negotiated by the endorsement of the holder completed by delivery. right? A bill is payable to bearer is transferred by delivery alone, right? Keep that in mind. Now, requisites of for you to negotiate the bill, like I said, you need to endorse the bill. So, how do you endorse the bill? Is written in section 32. You have right to have endorsement. Requisites of valid endorsement, right? How do you endorse the bill correctly? The endorsement must be written on the bill and be signed by the endorser. So you can't just verbally say that you endorse the bill. You have to literally sign it at the back of the bill and written on the bill and sign it. It must be an endorsement of the entire bill. If it's a bill of exchange for 100,000, you can't endorse 50,000. You have to endorse the entire bill, right? When the bill is payable to more than one person, all must endorse, unless one endorsing has the authority. For example, let's say a bill is drawn, the endorser, the bill is drawn in favor of the payee, and when the payees are going to, give it to someone else, the payees becomes the endorsers, right? So if there are two payees, pay A and B, both of them have to endorse it, unless one of them have the authority to sign on behalf of the other, right? Where the payee or endorser is wrongly designated or his name is misspelled, he may endorse it as the name wrongly appears and add his proper signature. Remember that. Let's say your name is incorrectly stated there. For example, you say, like your Sinhala surnames, you come across this a lot. Vijayavardhana, Jayavardhana, Nena, or DH Jayavardhana, DH or DA. Your name may be spelled as DA, but they say DH, or your name is something else, like that. If it's wrongly spelled, when you are endorsing, you have to write that wrongly spelled name and provide the correct signature when you are endorsing. Otherwise, it's not complete. Then you don't become the endorser. You don't get the capacity of becoming the endorser. Unless it's a variable, then it's a different story because there is no endorsement required at all. All right. Otherwise, that should be the case. If it's an order bill, an endorsement in blank makes it a bearable. Right? And section 34. An endorsement in blank specifies no endorsee and a bill so endorsed becomes payable to bearer. Right? Right. Okay. Now, a restrictive endorsement prohibits further transfer of the bill by the transferee. For instance, pay D only. It prohibits further transfer. Where a restrictive endorsement, right? Endorsement permits further transfer. Pay D or order for collection. All subsequent endorsers takes the bill with the same rights and subject to the same liability as the first endorser under the restrictive endorsement. Yeah, basically, in other words, you made this not negotiable. Right? We'll come to what is not negotiable later on. That means he doesn't become a holder in due course, all the subsequent endorses, because here you are saying pay D only. And the latter person, for example, an endorsement is restrictive, which prohibits the further negotiation of the bill, or which expresses that it is a mere authority to deal with the bill as thereby directed and not a transfer of the ownership. Bill is endorsed, A, B, O. Right? You have the term O. Pay D or D. O. Pay D for the account of someone else. You get that very much. For an example, let's say in testamental proceedings, when what do you call land of the deceased person was sold, and there is a testamentary proceeding is going is ongoing in courts, the money may not be just paid to X and Y. It may say for the on account of this, pay the executor, name of the executor on account of the estate of the deceased, like that. Or for an example, if it's a company liquidation, you can do in so many ways. One thing is you pay the liquidator directly, or you can say you can deposit it to an account which is open under the company in liquidation, name of the company in liquidation. So you can write it so and so company under liquidation, or to the liquidator on account of the company in liquidation. Right? Then it's a restrictive endorsement. You can't negotiate it further. If you negotiate it further, basically, right, there won't be a holding in due course. You will understand that when we learn, study endorsement. What is not endorsement, negotiability of a check. A better title is not transfer. You will transfer whatever title you have. What I'm saying is, I am the payee of this. I say pay. I endorse this as pay Amila only and endorse it. Amila gets this. So Amila is a holder in due course because he is the pay endorsing. If Amila tries to further negotiate it and say, Amila writes his name, endorses and say, or just blank endorsement, it becomes payable to the bearer. Amila won't give a better title than the title he had. If Amila took this bill from me under duress or fraud, I am not liable on that bill. I am not liable on that bill. Do you understand? So it doesn't pass a better title. Negotiation stops from that. That's the same result, or the same result comes when I write not negotiable. If I write not negotiable, I stop the hold in due course until the party named as the payee. For example, I write bill of exchange, pay Amila, Pereira, or bearer, and right, not negotiable. It stops from the first endorsement, either Amila or the bearer, first one. After that, I'm not liable. Right? That's the whole idea of making it not negotiable. Right? Understood? Questions?
Excuse me, sir. It means restrictive endorsement is same as
Similar. Not
similar to
negotiable.
yes. It means it does not prevent transferring a check.
No. It doesn't.
Okay.
It doesn't.
Only restrict the negotiability, right?
Very good.
Okay.
Section 35. Then we come to promissory notes, right? Promissory notes. Now, promissory notes, in bankers' terminology, we call it pro notes, right? About 17 years ago, I was, like I said, I was in the corporate. Well, I was in a bank. I just joined the bank, and all these banking assistants. I didn't know anything high and low about this at that time. And but he said, check the pro note, check the pro note. I said, okay, I just check the pro note, whatever the pro note is. Then after about 3-4 months, I asked somebody who was very senior to me in that particular department, note guy. The guy to go when you have a question. Why do you call what is a pro note? He said, and I asked, why do you call this a pro note? And he said, I don't know, because somebody else called it, I called it. So that was the day I decided you should do this. Always learn. Right? It need not be through a lecture. From your experiences, you learn. So from that day onwards, you do something, you know why you are doing that. If you don't know, that's nothing to be ashamed of. Find out from a person who knows it. If he doesn't know, that's also doesn't matter. To keep on finding, and after you found the answer to your question, go and tell that person, this is what it is, right? Otherwise, we don't develop. Don't think you are, giving away your knowledge. More you give your knowledge away, more you would be knowledgeable. Right? That's the beauty of, teaching. You get more knowledge out of giving knowledge. That's the only thing. It's like a waterbed, right? So promissory note is a type of a negotiable instrument. However, it's not defined in the bills of exchange ordinance, right? But strictly speaking, it's not a bill of exchange, right? It's promissory note, strictly speaking, is not a bill of exchange, because now bill of exchange, promissory note is treated as a bill of exchange simply because it's included in the bills of exchange ordinance. Now, in a bill of exchange, we discussed that there are a couple of parties: the drawer, the drawee, the payee, etc., are there. But in a promissory note, there are only two parties. So, because that, it doesn't come under the definition of Section 3. Under Section 3, there are only two parties to a promissory note. I promise to pay you X number of amount on this date after fulfilling this. It's a promissory note. It's more of a guarantee, right? Make of the note and the payee or the bearer. But in normal bill of exchange, there are three parties: the drawer, drawee, and the payee. Right? This is not the case in a pro note. It also should be distinguished from a check, because the check must always be drawn on a back. That's the difference between a check and a bill of exchange, right? All checks are bills of exchange. All bills of exchange are not checks, because checks are always drawn on the back. The drawee is always is a bank, right? You may be a finance company, you may issue a check, but you need to have a bank. The drawee should be a bank. Section 85. Section 85 defines what a promissory note is. Promissory note is an unconditional promise in writing made by one person to another, signed by the maker, engaging to pay on demand or at a fixed or determinable future time some certain money to owe to the order of a specified person to bear. So it has its own definition, not Section 3, right? An instrument in the form of a note payable to maker's order is not a note within the meaning of this section unless it is endorsed by the maker, right? A note is not invalid by the reason only that it contains only a pledge of collateral security with authority to sell or dispose there. note which is on the face of it purports to be made and payable within Sri Lanka is an inland note, or any other note is a foreign note. Right? Okay. So that's a promissory note. Right. Now, these provisions on bills of exchange ordinance does not apply to promissory notes. Presentment for acceptance, there is nothing like presentment for acceptance of bills of promissory notes. Acceptance is not there. Acceptance to proportion bills of sales, don't worry about those things. The promissory notes are peculiar kind given under the bills of exchange ordinance, which has their, it's quite straightforward than bills of exchange. The two parties just be familiar with Section 85. There are certain legal rules, important rules when it comes to bills of exchange, or rather negotiable instruments, right? An action on negotiable instrument is time barred, right? After a period of 6 years after the date of issue of the instrument, right? After the issue of the instrument. What it means is we are not talking about stale checks or these things. What it means is I write a bill of a negotiable instrument today, right, in favor of a payee, and there is a dispute between me and the payee, and if the payee wants to sue me, he can sue me within 6 years from today. That's what this basically means. This is given under Section 6 of the Prescription Ordinance. Kalavaroda Ajna Panata. Prescription Ordinance. Prescription Ordinance. Right. Then okay. So English law applies to bills of exchange, right? Keep that in mind. However, the legal procedure in Sri Lanka for you to follow in terms of, in view of a dispute or anything on a negotiable instrument under the Bills of Exchange Ordinance, you should follow the Civil Procedure Code, right? That's the procedural law. You have done debt recovery, right? Debt recovery law and also the recoveries of loans by bank special procedure. Now, if it's a normal legal case, there is a plaintiff and a defendant. There is a special procedure in addition to those in civil procedure called summary procedure on liquid claims. That is given under Section 701 of the Civil Procedure Code, Chapter 59. There, you don't need to go on the normal procedure. It's more or less something similar to Debt Recovery Act, but it's available for any party who is a holder of a bill. But Debt Recovery Act, it's anyone can't go under Debt Recovery Act. But anyone can go under Civil Procedure Code, Summary Procedure on Liquid Claims, 701. Something similar to Debt Recovery Act. So I'm not going to dwell much time on that. It saves time. That's why. It's only, you've been given that only for that right for claims based on bills of exchange, negotiable instruments. Right. Any questions? we have completed Bill of Exchange Ordinance. Next we have is the law relating to checks. But we are ahead of time. If you have any questions, you can ask me.
Excuse me, sir. In the current context, still these promissory notes and all are in use, or?
Oh, yeah. Quite a lot. Yes. Because you see, promissory note, moment you give a promissory note is more of like a personal guarantee. It's quite strong. It is used. There are close to 50 in the class, but only the same students ask questions. Others,
Excuse me, anyone can make a promissory note, no? No need of help of a bank or something?
no, anyone can.
Okay, thank you, sir.
Sir, are we having exam on November?
I saw something, I think Kavindra should be able to help you out on that. They have extended the deadline for applications, no? I'm not pretty sure about it. You might have to check it with the institute. All right. So today I cannot go to the next topic because I will have to stop it in between. Therefore, we'll have to wind up today. Unless you have questions, we can use this time for your questions. Believe me, you will hope such a time is there when it's near the exams. I might not be available during that time. No, yeah. So no questions, then we'll wind up.
Excuse me, sir.
Yes.
So this is regarding checks, sir. Can you please tell me, sir, how does a blank endorsement being done?
You basically you turn it around, you sign it. That's it.
Okay, sir. Got it.
All right. We can wind off for today. We'll meet next week.